Hi folks, Lee Pacchia here, and you're watching The Business of Law, where we talk about all the challenges and the opportunities facing today's legal profession. We're joined today by Mark Cohen. He is CEO and founder of Legal Mosaic. He joins us from his office in Washington, D.C. Mark, good to see you. Welcome to the program.
Good to be here, Lee. Thanks.
So I wanted to talk to you about a story that we've been covering in depth over on our criminal justice vertical fault lines, which you should all be reading, by the way. It's absolutely fantastic. I couldn't be prouder of it. But we've talked a lot there about the ongoing legal battles involving online publication Gawker. As many of you know, they were sued by former wrestling star Hulk Hogan over the publication of a sex tape involving him some years ago. That case resulted in a very large judgment, which forced Gawker to file for Chapter 11 bankruptcy. It has since come out, however, that billionaire Peter Thiel has basically funded this case, given Hulk Hogan the money to pay for lawyers and to pursue Gawker to the ends of the earth and ultimately drive them into the dirt. Mark, I thought that this was fascinating to find the business of law angle to this really, really interesting news story. Can't wait to hear what you think about it, particularly, when we look at it from the vantage point, litigation finance, it was always supposed to be about access to justice, I thought. Access to justice for people who are not billionaires. But here we are looking at a situation where litigation finance was employed by someone who had an awful lot of means.
Well, business finance, Lee, has had a long, strange trip in the last 20 or so years. It started out, as you suggest, as a way of leveling the playing field by allowing plaintiffs in certain types of cases to get funding to subsidize cases against deep pocket defendants. And it was largely in the personal injury area. But in the last few years, it's morphed into commercial litigation, more mainstream litigation. And now, in fact, you've got publicly traded companies, Burford and Bentham are two that come to mind, as well as various companies that are essentially private equity companies dabbling in the legal vertical, and more specifically in terms of providing finance capital for litigation. And it's become a multi-billion-dollar industry. The third component of this odyssey occurs, as you say, with the Hulk Hogan case, where you've got a billionaire who is not in the legal finance business, but who is himself a lawyer by training, was himself subject to a Gawker story that he didn't care about some years ago. And he had a strong personal and political agenda, and that was to bring down Gawker. And so he decided to fund Hulk Hogan's case, among others, by the way, brought against Gawker. And as you say, the bell was rung to the tune of $140 million.
Mark, tough question to ask here, but from a public policy standpoint, should someone like Peter Thiel be allowed to basically litigate a company, a publication to death in this manner? Is this a perversion of the principles upon which litigation finance is supposed to work?
First of all, Lee, I relish tough questions. And it's a very fair question, and I don't think that there is a yes/no answer. On the plus side, I think you've got a situation where if you put aside the fact that Hulk Hogan was Hulk Hogan, and you put aside the fact that Gawker does what Gawker does, you've got a situation where you have an aggrieved plaintiff, and even though the aggrieved plaintiff in this particular instance has some means, he may not have had the means or wanted to expend the means to pursue this claim as far as he needed to go to ultimately prevail. So in that sense, I think you could make an argument that, yes, there was a legitimate purpose served. The flip side of it is, of course, that whatever you think of Gawker, some think that, they have an absolute a right of free speech, and others say that it's just, free speech run amok. But whatever you say about Gawker, I think you also have to say that they did make a decision. They knew the consequences, and it's kind of interesting that although she was not employed by the company at the time, Gawker's general counsel also serves as the president of the company. And so in that sense, you have a situation where the GC has a dual hat in the company, which is quite unusual, particularly for a company that size. And you could argue that she certainly could have exercised her discretion, either as GC or certainly as president, to have settled the case, which he elected not to do. So there's a lot to this case, Lee.
So looking at what happened here, it has been suggested by some that it might be time for some rules and regulations around litigation finance. What say you?
Well, I say that probably that's a good thing. Exactly, how they're going to fall out, I can't say, but let's back up for a minute. For those of us who graduated from law school, and I know you were one of them, you remember an old British term, champerty, which generally means that you're not supposed to allow third parties with no interest in the litigation to fund it. The more modern adaptation of that is Rule 5.4, pardon me, Rule 5.4, which says basically that lawyers are not allowed to share profits or take outside investment from non-lawyers. Now, in this particular case, I guess you could argue that Mr. Thiel was himself a lawyer, but let's just assume that he was your ordinary billionaire who did not have a law degree, but did have a personal or political agenda or an axe to grind. In that particular case, you're left to wonder, how is it that either Mr. Thiel or, for that matter, litigation finance companies, can do what they're routinely doing? Kind of an interesting question to me. But I think the real question, Lee, is where you've got, corporations, and they are the principal clients, corporate legal departments are the principal clients of these, publicly traded litigation finance businesses, or where you have large law firms. Both of them are very sophisticated consumers. And so you could argue that they don't really need the same kind of protections that an ordinary citizen might. Indeed, litigation finance companies very carefully vet cases because it's a business. Most of the monies that they loan to corporations or law firms to fund litigation, which, by the way, has become a strategy for these corporations and law firms. These funds are generally non-recourse loans, which means that if the case doesn't succeed, the finance company ends up eating it. So the finance company itself is going to do significant due diligence in terms of the merits of the case. And likewise, the consumer is going to be fairly sophisticated, and they're not going to be looking to pursue cases if they don't think that there's a chance to succeed, especially where they're on the plaintiff's side. So I think that part of the marketplace has to be distinguished from the Peter Thiels of the world, who might just kind of be officious intermeddlers in the litigation process, not particularly caring whether they win or lose, but rather seeking to basically litigate someone to death, as you say.
So do you see that segment, the Peter Thiels of the world, do you see them getting regulated anytime soon?
I'm not so sure about that. It would be a slippery slope. I think probably it's going to be left alone for a while. If this becomes common practice, then perhaps there will be some, sort of agitation for regulation. But I do personally think that there has to be some sort of a distinction drawn between legitimate businesses who are giving, both consumers, sophisticated consumers and providers a certain flexibility that I think is good for the legal process. I think there's a distinction to be drawn between that and having, very wealthy people with an axe to grind being able to basically play fast and loose with the legal process.
Mark, fascinating story. Thanks for talking to us today, sir.
Always a pleasure, Lee.
That's Mark Cohen, founder and CEO of Legal Mosaic. If you'd like to see more of the stuff we're working on, be sure to go check us out online. You can find us at mimesislaw.com under the Business of Law tab. We're also on Twitter, Facebook, and LinkedIn. If you're listening to us as a podcast, do us a favor and write us a good review in iTunes. It makes all the difference in the world. If you're watching us on YouTube, do us a favor and subscribe to the channel. There's more good stuff coming. I'm Lee Pacchia. Thanks for watching. See you next time. Tell me about how this specific story happening in Europe right now plays into the themes that you discuss in your book.
Well, it plays in directly because I would say there's an extremely low probability that a exit vote would trigger a financial panic the way that the Lehman collapse did in 2008.